It's in. Okay, so this is in the matter of Orion Abbey LLC versus WGL Industries LLC, doing business as Giving Tree Gardens, defendant appellee. File number, circuit court case number is 23-7190 AB. This is Orion Abbey LLC's brief on appeal in file number 23-7190 AB and 23-7191 AB. Back to short stuff always looks different. So heading. All right, counsel, can you identify yourself for the record, starting with plaintiff counsel? And P number, please.
Good afternoon, Your Honor. My name is Tim Deemer. My P number is P65084. I'm here on behalf of the plaintiff appellant Orion Abbey.
I'm sorry, I didn't catch. I'm sorry, I didn't catch the last name, sir.
Deemer, D-I-E-M-E-R.
Thank you very much.
Samantha McLeod on behalf of plaintiff.
Okay, so you're very soft spoken. So welcome to my courtroom. Be loud, okay?
Samantha McLeod on behalf of plaintiff P84394.
How do you spell your last name?
MCLEOD.
Okay, all right, and counsel.
Good afternoon, Your Honor. Brian Garmo, P71007, appearing on behalf of the defendant, WGL Industries.
All right, you may proceed.
Thank you, Your Honor. And I greatly appreciate your accommodation to have us appear in person. I much prefer to be in person than by Zoom. So I'm really happy we could come here to your courthouse. This is plaintiff's appeal from two rulings of the district court by Judge Morgan on July 14, order dismissing the complaint, September 11 ruling awarding attorney's fees in favor of Giving Tree. If the court has a time limit, like to say 5 minutes for rebuttal. We're here to contest Judge Morgan's ruling primarily on liability. The ruling itself, it's in the transcript. It's ambiguous to me whether it was a directed verdict ruling, in which case my client, Orion Abbey, would be entitled to light most favorable review, or if it was a finding of fact under 2.517, in which case the judge's rulings need to be more definitive, more clear. There are a number of issues that were presented at trial that Judge Morgan simply did not rule on. One other standard review issue that we've presented is de novo review of the contract between Orion Abbey and Giving Tree. Read as a whole, read in a manner that avoids an absurd result. The contract has a 6-month window during which time Giving Tree is not able to poach a former contractor or current contractor of Orion Abbey. Under Giving Tree's interpretation of the contract, having only applied to current contractors, current employees, a contractor such as Mr. Bay could simply quit and say, voila, I'm no longer currently a contractor for Orion Abbey. I can go join Giving Tree or another contracting partner. That would be an absurd result. That's also not reading the contract as a whole. The contract as a whole includes a 6-month window post-termination during which the non-solicitation provision were to apply. That understanding of the contract is also supported factually. During the course of trial, testimony was introduced, where the parties, being Mr. Jindo of Giving Tree, Ms. Sneed of Orion Abbey, in November, roughly 5 weeks after the contract was entered into, discussed the idea of whether the 4 Orion Abbey contractors could be bought out by Giving Tree. And what that meant was Giving Tree fully understood, we can't solicit, we can't poach these employees. If we're going to do that, we've got to compensate Orion Abbey for hiring their contractors directly. Why would there be discussions about a buyout if there was not a solicitation agreement that would extend that extra 6 months? It makes no sense to even have that discussion. For the remaining issues, we'll rest in our brief. The trial court's findings were not definitive enough. rule clearly requires the court to make findings on contested issues. There was no finding as to when Mr. Bay was hired. There were conflicting facts on when that occurred. There were a number of credibility determinations the trial court did not make. The district court that we think should be addressed on remand. And if the court is inclined to remand the case back to the district court, we'd ask for the opportunity to file a supplemental brief for that to be included in the remand instructions so that the parties can present their views of the facts on remand in front of the district court to get a more definitive ruling. As for the attorney's fees, we'll rest on our briefs. Smith versus Corey, Pirgu, those cases all require the trial court to first determine a reasonable hourly rate, then a reasonable number of hours, come up with a lodestar factor, and then use the other factors to go upwards or downwards under the Smith versus Corey, Wood, and Pirgu factors. That was not done. Mr. Garmo, and I have no reason to doubt the veracity of what he had to say, told Judge Morgan at that point, I billed my client more than $30,000. That's above the jurisdictional limit. So give my client $25,000. That does not satisfy Pirgu, Smith versus Corey. And there's that issue. The other issue is 2405 limits the prevailing party attorney's fees to post rejection of the offer of judgment. It's not from answering the complaint through trial, it's post rejection. So that showing would also have to be made on remand if the court is inclined to reverse. Unless the court has questions, I may have a couple comments to make on rebuttal if that's okay.
All right, thank you.
Thank you.
All right, Mr. Garmo.
Thank you, Your Honor. So today's the date and time set for our oral arguments on the consolidated appeal following this two-day bench trial in the trial court. The parties both filed briefs that outline their positions on relevant laws, so I'm not going to go through everything. It looks like you carried in both of this heavy file as you walked in today. So the plaintiff has three questions presented for this court today as outlined in their brief. The first question presented is, did the trial court properly dismiss plaintiff's action? And the answer is yes. MCR 2.613 subsection C provides, quote, findings of fact by the trial court may not be set aside unless clearly erroneous. In the application of this principle, regard shall be given to the special opportunity of the trial court to judge the credibility of the witnesses who appeared before it. After a review of the entire record, the reviewing court here must be left with a definite and firm conviction that a mistake was made before a reversal is warranted. The plaintiff makes an entire argument in its initial brief that it files with this court that the trial court improperly granted a directed verdict. The Michigan Supreme Court has recognized that the appropriate label for a motion requesting a directed verdict may be made in a case without a jury is in fact an involuntary dismissal pursuant to MCR 2.504B2. MCR 2.504B2 provides that in an action tried without a jury, after presentation of the plaintiff's evidence, the court on its own initiative may dismiss the action. The court may then determine the facts and render judgment against the plaintiff. And that's exactly what happened in this case. I was a trial attorney. After the plaintiff rested its case, that's when I did move for a motion for a directed verdict, but the court on its own initiative rendered its opinion. So the plaintiff here is not given the advantage of the most favorable interpretation of the evidence standard. Judge Morgan was very attentive at trial and took very detailed notes. I vividly recall this. When Judge Morgan ultimately dismissed plaintiff's action, he was very thorough on the record and oftentimes cited his own notes. The trial court heard conflicting testimony from witnesses, and the trial court made a decision after weighing all the evidence before the court. So the second question presented by the plaintiff in their appeal is, did the trial court provide sufficient findings of fact? And our position again here is yes. MCR 2.517 provides that brief, definite, and pertinent findings and conclusions on the contested issues are sufficient without over elaboration of detail or particularization of facts. The trial courts met this threshold and stated findings and conclusions in the record. The fact that plaintiff disagrees with the findings by the trial court is frankly irrelevant. The Court of Appeals affirms that whereas here, witnesses contradict each other it is up to the trier of fact to determine credibility. And the trier of fact can choose to believe all, part, or none of the testimony. And that's exactly what happened here with the trial court. The Court of Appeals also held that the trial court need not necessarily engage in elaborate discussion because brief, definite, and pertinent findings and conclusions on contested matters are sufficient. So that's all we have to do is be brief, definite, and pertinent, and those are in there. It doesn't have to be over every single little issue. In this particular case, the trial court concluded that Malik Bey, the contractor in question, was not an employee or contractor for plaintiff at the time he began working for a defendant. And he also made a ruling that the plaintiff is the one that drafted the contract. So the contract should be interpreted against the drafter. The third question presented is, did the trial court abuse its discretion in determining the amount of attorney's fees to be awarded? And our position again here is no. A trial court's award of attorney's fees is reviewed for abuse of discretion. Abuse of discretion only exists when a trial court relies upon clearly erroneous factual findings, applies the law improperly, or uses an erroneous legal standard. And the appellate court has stated, the appellate court cannot overturn a district court solely because it would have made a different decision under the circumstances. The reviewing court must review the lower court's ruling on an award of attorney's fees. This reviewing court must find that the lower court's ruling was arbitrary, unjustifiable, or clearly unenforceable. And the district court's exercise of discretion is entitled to substantial deference. The basis of granting defendant's motion for attorney's fees is that plaintiff rejected defendant's offer of judgment. At that time, defendant believed that plaintiff's action was frivolous, but it submitted the offer of judgment as a business decision with the hopes of just ending the matter and being done with it at that time. The plaintiff rejected the offer. He knew he rejected the offer, testified at his deposition that he knew he could be subject to attorney's fees by rejecting the offer. And for the record, all the attorney's fees that I requested that we put on the record all occurred after the rejection and the time period elapsed, after the formal rejection of the offer of judgment. Nothing happened prior to that time period. In granting defendant's motion for attorney's fees, the trial court reviewed defendant's motion, brief, and supporting materials. The trial court granted or awarded the district court statutory limit of $25,000 in attorney's fees, even though the attorney's fees and costs after the rejection of the offer of judgment, in fact, totaled $33,262. So that consisted of $31,762.50 in attorney's fees, $1,499.50 in additional costs for the court reporter fees for the depositions. The figure that my client was ultimately awarded comes out to about 75% of the actual figure that we just stated. And for the record, when we were at trial, before trial started, the plaintiff himself, the plaintiff's owners, owned by a sole member, represented that he in fact paid his attorney over $12,000 in attorney's fees before the trial even started. Before the trial started. This action was an enormous amount of work. And even plaintiff's trial attorney told me that had such a law, like a larger law firm as Dickinson Wright or Miller Canfield represented my client, that the fees that my clients would have incurred would have been significantly higher. We did extensive discovery. We prepared for and took depositions. We prepared for and argued a motion for summary disposition. We had motions for reconsideration. We had trial preparation in a 2-day trial. And that's what ultimately culminated in the 2-day trial. I currently bill at $350 per hour. I billed this client $330 per hour. That's what I had them grandfathered in. I submitted evidence that the plaintiff's trial attorney charges up to $350 an hour himself. The plaintiff himself testified at his deposition that for his executive collection work, and he has no legal background, he charges up to $600 an hour himself. So the fees that I'm requesting are not exorbitant. I cited the Michigan Economics and Law Survey from 2020 that cites everyone in my geographic area. Everything is broken down. The case law here supports that an evidentiary hearing, it's not required. You don't have to have an evidentiary hearing. It could be one. The Court of Appeals held that a trial court does not err in awarding fees without first conducting an evidentiary hearing where the parties created a sufficient record to review the issue and the court fully explain the reasons for its decisions. And the trial court did that in this particular case here. The trial court's decision to refrain from conducting an evidentiary hearing is reviewed for abuse of discretion. And there's no abuse of discretion here. In plaintiff's brief, we believe that they incorrectly rely on Patterman v. Haverhill Farms. In that case, the Court of Appeals reversed and remanded an award of attorney's fees where the trial court failed to consider any of the Wood factors and made no findings of fact as to the reasonableness of the fees requested. In this particular case, the trial court did consider the Wood factors. The court's not required to give detailed findings of fact regarding each factor. They just have to consider the Wood factors. And for the record, when I did go to the motion for attorney's fees, I did have an invoice with me. The court never did ask me to provide. I had an invoice with me, but I don't have invoice statements. The way my invoices work, the way our firm does is there's entries, and it's a little Excel spreadsheet. The left-hand side will say the hours I billed. Then the middle section will have a statement of like detail what I did. And then it does the math on what I've done. So to be honest with you, I don't feel comfortable. I don't mind disclosing that to the court. I don't feel comfortable showing it to the opposing side because it has attorney-client privilege things in there where I put in there, discuss this sort of strategy with my client. I put whatever it may have been with the client. So I did have it ready. I tried to redact as much as I can out of there. So I did have it ready at that time. So as it relates to the relief that's sought, we're requesting that this honorable court to affirm the trial court's orders in their entirety. Thank you.
Sir?
Thank you. Just a couple brief comments on rebuttal. I'll work backwards. I agree 100% with Mr. Garmo that legal invoices include confidential privileged information. When we have attorney's fees disputes and we are requesting attorney's fees, the appropriate procedure is to submit heavily redacted invoices to the opposing party and to submit unredacted to the court.
Right.
On that point, if the trial court is going to be given discretion to cancel a hearing, that rule only applies if the trial court has all the necessary information at its fingertips to make this ruling. Here, Judge Morgan did not have the invoices redacted, unredacted. So Judge Morgan would not get the benefit of discretion to waive the hearing. Again, going to work backwards and hopefully finish where I started. We're going to request, in addition to the interpretation of the contract that we've set forth, a remand with opportunity to brief the judge's findings. There are a number of rulings the trial court did not make. Trial court seemed to suggest that Orion Abbey didn't meet its prima facie case to submit a trial issue effect. It's unclear if that was the ruling or if it was findings. If the ruling was based on factual findings made by the court, they need to be more definitive. They need to address a number of the issues that were presented at trial, namely the central dispute: when was Mr. Bay hired? The trial court, in making its ruling, only made one credibility finding one of plaintiff's witnesses not to be credible. There was a lot of contradictory, incredible, unbelievable testimony offered by Giving Tree that Judge Morgan did not go through. That should be part of the remand. And then to conclude, the two issues couldn't be further from each other: contracts, attorney's fees. But both of them, on review of a bench trial, depend upon the trial judge making definitive rulings, going through the evidence, weighing testimony, weighing credibility, and articulating the actual findings of the court, and articulating the reasonable attorney's fees. With that, Your Honor, I'll rest.
Mm-hmm. So thank you, gentlemen and lady. A review of the transcript of the trial court's rulings indicates that while the trial court did consider the evidence presented and, as noted, did take notes and noted the critical facts in its view, it is still unclear what specific findings the trial court made. Accordingly, this matter is remanded to the trial court to make specific factual findings and conclusions of law pursuant to MCR 2.517A. This court renders no opinion at this juncture regarding whether the trial court's decision was appropriate as the record is incomplete. And the trial court is certainly permitted to affirm its prior ruling by simply detailing its factual findings. And will order that the parties can file supplemental briefs. As to the issue of attorney fees, the court remands that issue to the trial court for specific findings regarding the Smith v. Corey factors after review of invoices submitted by counsel. It is this court's practice to require the parties requesting attorney fees to submit invoices numbered individually and require the objecting party to provide supplemental briefing referencing specific objections to the individually numbered invoices for ease of reference. The requesting party may then respond as to the reasonableness of the request. It may be prudent, and I think you already do that, so that's great, to do this exchange in a spreadsheet with one column identifying the invoice number, another column identifying the specific time billed and purpose, a third column indicating the reason for the objection, and a fourth column indicating the requesting party's response. I will also order that the parties can redact heavily to remove any confidential attorney-client information. That format, to me and for us, always makes it clear when the court issues its ruling regarding the reasonableness of each specific request. The trial court is not required. Well, I'm just gonna order you do it and provide it to the trial court for them to make their findings regarding the Smith v. Corey factors. So this will be remanded. Who's preparing the order?
I'd be happy to go ahead.
Okay. When can you file your supplemental briefing?
Get one, I'd say, yeah, I'm glad we're having this conversation. I would think it would make sense to do, maybe Judge Morgan will disagree, to do the findings first, and then if Judge Morgan reaffirms the ruling, then get into the attorney's fees. So maybe it would make sense to do a supplemental brief on the liability rulings first. I could have a brief in 21 days if that's timeline is acceptable to you. And then move on to attorney's fees, because if the judge changes his mind, says, no, I don't.
We don't need supplemental briefing on attorney fees because you're gonna do this Excel spreadsheets and I just.
You stole my thunder. That's exactly what I was.
Okay, yeah. So just on the ruling itself.
Yeah.
Well, here comes my boss. Okay. So he can, okay. So this is Sierra McGrain, who's my brilliant judicial attorney and tells me when I'm wrong all the time. So because, and I didn't think about that, this was a directed verdict, possibly ruling. So you're not entitled to supplemental briefing.
I'm sorry.
She doesn't believe that you're entitled to supplemental briefing on this because of the nature of the ruling. So I'm not going to order them at this time. If something happens down there, you can discuss that with Judge Morgan, but I am going to order that you guys do the Excel spreadsheets.
Okay. And Your Honor, I'm gonna have one, the way my invoices always are. It's one long invoice.
But it's got to be set up so there's columns for both.
Oh, they're all the columns are there. I don't send out, like some attorneys send out a monthly invoice where here's what you get this month or that. No, it's gonna be long. It's gonna have everything broken up in there.
And room for him to add his columns.
We can certainly do that.
Because
Can I have is there a way, do you want me to send the trial court the full version unredacted and send Mr. Deemer the redacted version?
Usually what we do is, if I remember correctly, and Ms. McGrain will probably pipe in, usually when we get it, so Judge Morgan's not even going to have to see you guys technically. He can just do a written opinion or ruling, but usually you guys exchange that and submit it to the court.
Okay, that's fine.
And then we just go through
I
it.
have no problem with that.
I don't want to argue with the boss. But what I will say is, if the ruling is directed verdict, then the only issue for Judge Morgan is whether there's a prima facie case that the contract was breached.
Right.
If it's going to be findings of fact under 2517, then I do think it would be appropriate, with all due respect to the boss.
But we don't know what it was yet. right? So if it comes back findings of fact, you could probably request.
Yeah, that's I'm just trying to, maybe it would make sense for us to try to have a status conference with Judge Morgan where we can have that conversation, because if it's directed verdict, then it's just.
If it's a directed verdict, you're done, right? So, I mean, with that ruling and that issue.
And if it's directed verdict, if prima facie case or not, that's one thing. And if Judge Morgan says yes, or if you did make a prima facie case, I need to make findings of fact, then I think it would be appropriate to do some sort of a supplemental brief on remand, give the judge all of the evidence in favor of our view, he give the evidence in favor of his client's view, and have a findings of fact or two.
Well, and you're not entitled to supplemental briefing on a directed verdict, right? So I'm gonna go with that. So I guess if his ruling is something different than that, you could probably ask for a status conference and ask him for that. How's that? Okay. All right. Well, I wish you the best of luck in district court. Thank you.
Thank you, Judge.